Well, the U.S. Supreme Court today denied a request to review the cases of several Guantanamo Bay detainees fighting their treatment and their detention at Gitmo. The High Court sided with the Obama administration, refusing to review the cases filed by the prisoners. As you probably know by now, 169 prisoners are being held at Gitmo, including the terror suspects who claimed responsibility for the attacks of 9/11. Context and perspective now from our senior judicial analyst, Judge Andrew Napolitano.
Chap.
Explain me.
Well, at the tail end of the Bush administration in 2008, the Supreme Court of the United States ruled that the right to habeas corpus, the right to force the government to try you, reveal the evidence against you, or free you, applies to everyone, all persons, American and non-American, those who wish us well, those who wish us ill, and it applies to the people in Guantanamo Bay. And it ordered that the federal district court in Washington, D.C. hear these applications from Guantanamo Bay detainees, meaning the government had to reveal the evidence it had against them and how it got the evidence. So of 59 detainees who asked for these hearings, the court ordered 32 of them released and 27 of them kept in prison. None of the 32 has yet to be released. So they filed appeals to the Circuit Court of Appeals, which invalidated those release orders, and then they asked the Supreme Court to hear that appeal, and today the Supreme Court said no. So we are left with a terrific 2008 decision, which says that habeas corpus, basically, the government can't lock you up without evidence against you. Applies to everyone, no matter who they are and no matter where the government restrains them. And yet when the decision is applied, it doesn't work the way it's supposed to work because the person's ordered freed or still incarcerated.
Remember, after the attacks of 9/11, there was a widespread belief by many who are experts in these matters that we might have to change some of the rules in this nation.
Yes, there was.
And it sounds like what you're saying is, rather than changing the rules, we have decided without deciding to break the rules.
You know, Shep, there has been an age-old argument, and all lawyers and even law students and legal scholars and judges know this, about whether the rights protected by the Constitution protect all persons or just Americans. A lot of us who follow these things for a living thought that once and for all, that argument had been resolved in favor of it protects all persons. The language says persons, it doesn't say Americans. So you're right. On paper, this looks terrific. But in the practical application of it, the Supreme Court has allowed lower court federal judges to eviscerate, to destroy, to gut, to render useless this opinion. And darned if we know why.
So what's happening is, rather than following their rules, they're just releasing these people.
No, they're not.
Or in other cases, holding them forever without going through the process.
They're going through the process. A trial judge says this is not competent evidence. You cannot base a conviction on this evidence, so I'm going to order this person freed. The government appeals that, and the Intermediate Appeals Court says, well, we disagree. We think that evidence is competent. Then these people appeal it to the Supreme Court. The Supreme Court says, we're not going to hear the appeal. Bottom line, no one has been freed since that decision in 2008, except the person who brought that 2008 case. The others have been kept incarcerated, even when the judges who heard these cases said, you can't get a conviction based on this evidence.
And is there a word of what happens next? Do we just continue to hold people?
Well, theoretically, these people will get another shot at freedom when the government prosecutes them. Of course, we know how long that takes. The 9/11 people, had they been prosecuted in federal district court in New York, probably would have been executed by now. The military tribunal is yet to commence.
Wow. Judge, you're like a broken record.
Well, you know, the Constitution means what it says. A lot of us believe that.
Yeah.
But a lot of the people applying it don't.
Judge Andrew Napolitano, thank you.
You're welcome, Shep.
Members of the white supremacy group, the Ku Klux Klan, say they want to take part in Georgia's Adopt a Highway program and sponsor a stretch of roadway in the Appalachian Mountains. That's apparently put state officials in a very tough spot. Like many states, Georgia thanks its contributors by giving them their own special signs along the highway. The State Department of Transportation is still reviewing this new application. The man who filed the request on behalf of the KKK tells Fox News he just wants to clean up the road. But at least one state representative has spoken out and loudly telling Fox News it should be denied just as we would deny the request from any other hate group. Back in 2000, the state of Missouri lost a similar fight with a group of the KKK. A federal appeals court ruled that under the First Amendment, the state could not deny an Adopt a Highway application just because officials disagreed with the group's point of view. Our senior judicial analyst, Judge Andrew Napolitano, is back with us, as is the criminal defense attorney and Fox News legal analyst, Mercedes Colwin. You know, those against this are like, look, this is a hate group that is looking to pick up new membership and rebrand itself. And if the state goes along with this, the state is complicit.
Look, this is a hate group that would reject Mercedes, reject me, reject a lot of people watching the show now. But hate speech is protected in the United States of America. The Supreme Court has ruled that way. And this circuit court in Missouri, which is a different one than the one that would look at this if it emanates from Georgia, in my view, properly ruled that way. If this were a private highway, then you could decide who you wanted to do business with. And you could say to them, I'm not going to buy your product. I'm not going to put your sign on my private highway. But because it's owned by the government can't make a decision based on its opinion of their opinions.
They could, Mercedes, they could do away with the program, which they don't want to do because budgets are so short. 4,100 individuals and like 173 active organizations have been involved with this program. If they don't do that and they let them in, there's one thing, and if they just deny them, can face a tough legal battle.
Oh, I think so. And plus the state of Missouri has already come out and said, wait a minute, we have anti-discrimination statutes, and this particular group actually promotes discrimination, so therefore we can't sanction it. We can't certainly have them up on a sign. So they really put up a valiant fight and said, hey, this actually violates federal law if we allow them to actually put up that sign. But I think the fallout's going to be a practical one. You put up that KK sign. Do you think someone like me, I have a sign to clean up the highways. You think someone like me or another business owner is going to say, I'm going to put up the sign so they can see my sign before or after the KKK sign? They may have a fallout as a result of actually being forced to put up that sign.
Some very broad guidelines in the state of Georgia. I'm going to read you the line. Any civic-minded organization, business, individual, family, city, county, state, or federal agency is welcome to volunteer. They could change the guidelines, I suppose.
I suppose they could change the guidelines, but it would be very difficult for them to reject this organization on the basis of their First Amendment views, as hateful and reprehensible as those views are. Because they could then say, well, we reject the views of certain right-to-life groups because we think that their interference with the right of women to have abortions is hateful. And where will this stop? Where it stops is, the Supreme Court has said, free speech is free speech, and the state can't discriminate.
But here's the difference, though, Judge, respectfully. He is a judge, so I've got to be respectful. Respectfully, here are a couple of things. One, this group has a history of violence, has a history of violence throughout the decades. So there may be a difference that they can actually split hairs here and say this is something that we can deem it to be a public safety issue if we start promoting a group that has for decades promoted violence against people who are of color.
This is a wonderful argument, which ought to be made, because this group should be driven out of town by the force of opinion, not by the force of law. And the federal courts in Missouri have stated as much.
The guy who filed the application is named Harley Hansen. Let me read you this. He said he is the exalted Cyclops of the Klan's realm of Georgia. Cyclops usually has one eye. But anyway, quoting here, we just want to clean up the doggone road, the 34-year-old electrician from Blairsville said in an interview with the Atlanta Journal-Constitution newspaper, and we appreciate the quotes from them. He goes on to say, and I quote, we're not going to be out there in robes, but they could be, because there is no dress code for Adopt a Highway folks. You know, the brownies and the Weeblos, little kids go out in their little brownie costumes and their Weeblo costumes, and little boys and girls learn about cleaning up, and that's a great lesson to learn. Why couldn't the Knights be out there in the dang things?
And there's the public safety issue. Talk about the incredible distraction, Judge. Don't you think that could be a real issue if you see them along the highway, the catastrophe that can befall?
I agree with you. I agree with everything you're saying, but there is no value in our history more sacrosanct than freedom of speech. And the state cannot get in the business of repressing it.
It's not unfettered.
This happened on a football weekend at Ole Miss a couple of years ago. There was no way to keep them out because you can't keep them out. And what they're getting here is a boatload of publicity, including 5 minutes on studio.
The force of opinion should make their presence difficult and uncomfortable, but the force of law cannot make their presence gone.
They just really want to plant posies along the highway. That's really what it's all about.
That's all it is. They're very nice people.
They want to talk about them like we're doing now.
I love the one quote from the one guy. Oh, I lost it. I love my race. Does that make me wrong? I'm proud to be white.
And I only want to socialize with whites.
Thank you both.
You're welcome.
We'll take this to our legal team now. Our senior judicial analyst, Judge Andrew Napolitano, here again, as is Mercedes Colwin, our legal analyst. You know, this is going to be a difficult case because it's so difficult to talk about the allegations here. It's just
Yes.
stomach churning, but they have a problem. The timeline is difficult. It's been so many years, and that complicates things in court.
That is an argument that the defense will make, which is, how could this possibly have been as horrific as you say it was if you didn't tell anybody about it until the other stuff about Jerry came out recently? Look, Shep, lots of times juries do not accept a defense like that. If the jury finds that the allegations occurred as the witness said they did, and the court let the jury hear this stuff, even though it allegedly happened a long time ago, that's usually a sufficient basis to convict. And the reading of the love letters, if you want to call them love letters, of the letters, will no doubt force Sandusky to take the stand and try and explain away those letters and thus expose himself to a withering, days and days long cross-examination by the prosecutors.
I'm sure he'll do as well as he did when he was interviewed on air. If he actually takes a stand, which would be the absolutely catastrophic for his defense, for he does. But I think the prosecution just has to put it in center stage and say, look, these are boys. These were very vulnerable children that were being manipulated, exploited, sexually abused by Sandusky. And the fact that they didn't come for decades, well, there's a lot of shame attached. I worked in sex crimes at the DA's office. The most vulnerable population and the least likely victims to come forward are boys. Why? Because there's so much shame attached to it. And that's why they didn't go forward. But this prosecution's got to put it where it is and say it's not about money, it's about shame.
This is an enormous case for every one of the individuals concerned with this, and I would never begin to minimize it in any way. But there is more to come. The NCAA and the Board of Trustees and all the rest are waiting for the end of this trial. If this man is found guilty of these things and put away for the rest of his life, and Penn State University is found to have used a lack of institutional control, Penn State University could be in trouble you cannot get out of.
Penn State University will have to sell some of the real estate in order to pay the judgments that jurors will impose against the university on account of the harm done to these kids if Sandusky is acquitted. This is a financial catastrophe potential for the university and for the state of Pennsylvania, which owns it.
The bonds have already been, following Sandusky's controversy, the municipal bonds have already been affected. They've cratered as a result, so you can just see.
And one other question that the world will be asking is, when you have a man who's in charge and who is almost godlike on a campus, in the way that Joe Paterno is, do blind eyes get turned, and does a lack of institutional control become almost a symptom of this status that he had attained there? Whether true or not, the perception may be there, and Penn State University could be in very big trouble on the athletic side. Don't let anybody tell you that this is one that couldn't end that program.
Right.
Because this could end that program. I'm not saying it will, but it could.
But it definitely could.
It could.
Yes.
A lot ahead, and it's going to be gross.
Oh, yeah.
A new effort to crack down on your potty mouth. Damn it. Citizens of Middleborough, Massachusetts are set to vote today on a proposal that would do the unthinkable. It would have police handing out tickets for public cursing. Recent reports in local media describe the town as being in the grips of a cursing epidemic. Poor Middleborough. The Wall Street Journal reports some locals say they're scared to leave their homes for fear of being verbally accosted by gangs of foul-mouthed ruffians.
Oh, my Lord.
Massachusetts?
Yeah,
Have they ever been to a
exactly.
Patriots game? Don't ever get near a Patriots
Boston
game.
Red Sox, please.
Please.
Come on,
I don't,
give her a break.
I don't know. Put a fence around your house and never leave.
The whole reason,
what are they talking about?
Well, the whole reason the First Amendment was written was to prevent the majority from repressing the speech of the minority, no matter how hateful or irritating it may be. This is a classic example. The town does not have the authority to vote to outlaw words, any words whatsoever.
Okay, it's a $20 ticket to anyone who publicly accosts another person verbally with profanity. He says it's not just like you're sitting around talking with your friends and you're like that. But if you, for instance, quote, profane language at some attractive female walking through town.
Oh, forget that here, right? I have one word to say, a few words to say, bleep, 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 bleep. Give me a break.
Yeah,
it's like when they tried to institute a
you
ticket.
can't stand up for yourself, Mercedes. It's going to be very difficult when the bad man says bad words about you pretty.
That, of course, is
I usually get the mommy stuff.
That,
Hey,
of course,
mommy.
is an equal protection problem, as Mercedes knows. The statute would protect women, but it wouldn't protect men. There are so many constitutional defects.
Mercedes,
look, if somebody is pointing their finger in your face, that's accosting.
Yeah.
But if someone is using language you don't like, that's not accosting. Just
believe me,
walk the other way.
I can take care of myself. I'm a litigator.
Oh, I'm well aware you can. All right, Middleborough, good luck to you. Glad to hear you have no problems.
Well, the House set to hold a historic vote deciding whether to hold Attorney General Eric Holder in contempt of Congress. This stemming from allegations that he may have lied or withheld information related to the Fast and Furious gun-running scandal. Holder insists he did nothing wrong and will testify again today.
Wow, is the highest lawyer in the land in serious trouble? And what kind of trouble is it, if any? Let's ask Fox's senior judicial analyst, Judge Andrew Napolitano. Judge, what is he looking at?
He's looking at a potential prosecution. Contempt of Congress is a crime for which someone in the Justice Department, of which, of course, he is the head, would have to seek an indictment from a grand jury, and then either the same prosecutor or another would have to prosecute him before a judge or a jury. So there are many, many steps to come. The last time we saw this confrontation was with Attorney General Janet Reno. A committee of the House of Representatives voted to hold her in contempt, and it sort of stung her reputation. It never went to the full House, and there never was a prosecution. So there are many steps to go. First, a committee votes, then the whole House votes, then the House has to persuade someone in the Justice Department to prosecute him, or the House has to ask a federal judge to appoint a special prosecutor. This is not going to be over tomorrow, but the sting of contempt to a lawyer can stay with you for the rest of your professional career.
Let's listen to the spokesperson for the president, Jay Carney. Here was his reaction to a possible contempt.
Attorney General has also made clear that he takes the allegations that have been raised very seriously, and that is why he asked the Inspector General to investigate the matter. It is also why you see the department cooperating with congressional investigators, including producing 7,600 pages of documents, and including testimony at hours and hours of congressional hearings.
Okay, now normally the spokesperson does not read statements, so obviously that's been legalized to make sure he said exactly the right thing. Would you read it that way?
I don't think they want this to happen. The White House really doesn't want this to happen now. We're 5.5 months from a presidential election, and Attorney General Holder has been a weak link for the president politically in his cabinet. Look, here's the reason for the ire of the House of Representatives. They asked for all the documents relevant to Fast and Furious. The Justice Department coughed up what they claimed was relevant.
7,000 pages.
Right, and then the House investigators on their own found highly relevant information showing that the Justice Department at some of its highest levels must have known about Fast and Furious, documents which had not been given by the Justice Department. That's why they believe that he willfully and knowingly held back information.
But I believe, and it's a little out of this area, but I believe Republicans really don't know if they want this fight either 5 months out of the election, because this could create a truly partisan atmosphere when it might not be necessary.
I agree with you. Let's just say that not all Republicans are in favor of this. I don't think there's going to be a vote in the full House until they know that they have the numbers.
I'm not sure the Speaker is.
Well, the Speaker is in a political thicket because the really conservative members of the House are actually threatening his speakership if he blocks this.
Right.
Congressman Louis Gohmert, who's a friend of ours and who's been on the show, has basically said if John Boehner doesn't go for this, it's time for new leadership in the House.
Right. So it's dicey for both parties.
Yes, it is. Right. Yes, it is.
Well, we'll have to continue to watch, see what happens.
We will as it plays out.
Judge Andrew, Peter, Napolitano.
Yes, Gretchen Elizabeth.
Great to see you.
You too, Kilmeade.
Yeah, that's mine.
What's your middle name?
My middle name is Michael.
Good to know.
That's good.
All right, thanks, Judge.
Okay.
We're going to take you back to Capitol Hill, where you're going to be seeing the Attorney General Eric Holder in just a moment. He's testifying before the Senate Judiciary Committee. And just a few minutes ago, Senator Cornyn, who will be our guest next hour, we should mention, just called for the Attorney General's resignation. So that's what's happening now in the Senate. A separate House committee is looking into the Fast and Furious gun-running scandal, scheduled a vote for next week on whether to hold the Attorney General in contempt of Congress for withholding documents in the case that they want to see. Judge Andrew Napolitano is a Fox News senior judicial analyst and joins us now. So we're going to continue to kind of dip in and out potentially of his testimony. Judge, but explain to us the process when a panel will vote to hold someone in contempt. What happens?
Well, the vote by the panel merely sends that vote to the floor of the House, and then it's up to Speaker John Boehner whether or not he wants to permit the entire House to vote on the citation of contempt. And if he says yes and the vote is affirmative, then the House has voted to hold the Attorney General in contempt. That alone has no legal ramifications whatsoever. Ordinarily, when the Congress votes to hold someone in contempt, the Attorney General assigns a federal prosecutor to prosecute the person whom the Congress has held in contempt.
Why?
Because contempt is a criminal act, and one is only guilty of contempt after having been found guilty by a judge or jury. Prior to that, it's just political. So for a Republican-dominated House committee and a Republican-dominated House of Representatives to hold him in contempt probably will not cause him any sleepless nights at all. The Republicans did that to one of his predecessors, Janet Reno. The full House didn't vote, but a committee did.
So how long does it take? If the goal is to get these documents to solve a problem that some Republicans believe is a problem, what kind of timeline are we looking at?
That's the very interesting part here, Jenna. If the goal is to get the documents, the threat of holding him in contempt will probably spring loose the documents. If the goal is to prosecute and convict him for contempt, that will take a couple of years, and it will require a judge to appoint a special prosecutor to prosecute the Attorney General, and that process will punish him, but it probably will not spring loose the documents.
Judge, just your thoughts on this. The Attorney General said to the panel today, the committee, I'm willing to sit down. Let's work this out. Let's do this face-to-face. That's his offer, and he says he's not going to get an answer, or he's not getting an answer on that. Just as a judge, someone that could do mediation. Do you think that's the path to go, or do you think this threat of contempt is now where this has gone?
I think the path to go would be for a federal judge to review the documents in secret and decide which are relevant to Congress's inquiry, which are lawful for Congress to have.
How does that happen? Does that have to be ordered by the Attorney General to have a federal judge to do that?
Well, no. The Congress could file a lawsuit against the Attorney General, and that lawsuit would go before a federal judge, and the federal judge would say, you know what, bring those documents into my courtroom and I'll decide what you get. The Attorney General wouldn't be deciding, and the House of Representatives wouldn't be deciding.
So there's a couple paths we could potentially take.
There are a couple of paths here. I'm sure he wants to avoid the citation of contempt. It's an unpleasant thing, but it's probably not going to pry loose the documents. What happened here is the House's own investigators found documents that he didn't cough up. That's why they're so animated.
That's why we're here. All right, Judge, we'll have you back as we continue to follow this story, as always.
Pleasure, Jenna.
Thank you very much.
Okay, had that scene taken place, let's say in Middleborough, Massachusetts, Joe Pesci would be coughing up some serious cash. That's because its residents just instituted a fine for public profanity. Each offense is $20, but is it legal? Let's ask the judge. Is it legal, Judge?
In a word, no. It is not legal.
Why not?
You can use foul language in public and you can use it in private because it's protected by the First Amendment, because the Supreme Court has said so, including a case involving the very words that Pesci used, which we would have heard had you not been so Victorian and beat them out.
And that was protected speech?
Yes, it
and
is
in New
protected
Jersey,
speech.
you helped make sure it was.
Well, and
you were responsible for the degrading of our nation. Explain how you let that happen.
In a case in which I represented, this is after I left the bench, a very famous basketball coach who used the F word toward a reporter who asked him a question he didn't want to answer. The charges against the coach were dismissed when the court ruled as a matter of law that that word is an intensifier. It is part of our language, and it can be used with impunity in public. I suggest to you that the Massachusetts Supreme Judicial Court, which is the name of the state's highest court, will rule the same way the first time someone is
actually
charged
fined
for this.
Right?
Correct.
You know, if they did this, we were saying at Fenway Park, they could balance the budget
of the state of Massachusetts
in one game.
As a practical matter, don't the police have better things to do than to go after people for this?
Well, you know, I'm not a Victorian prude about this sort of stuff. I will say this, though, with little kids, and there's some words that even I'll entertain, that's fine, but when you get into the big ones, you know what I mean, the bad ones, with little kids, is it necessary?
No.
Shouldn't they be reprimanded?
Well, yeah, but the better way to do it is not to involve the police and not to involve
well, they won't listen if you tell them. If you've gone to Fenway, as I have, And I turn around and I said, my good man, if you'll be so kind as to...
Did you actually say that to somebody at Fenway?
No,
Did you
I
actually bring your young children to Fenway?
No, because it was Hannity behind me, and he cursed like a sailor. But, you know, but there's no protection for that, right? You just, that's the way it is. You're free to say anything.
The beauties of being an American is you can say what you want, where you want, how you want, and the government can't punish you.
So you're
for it.
fine with this slippery moral slope, you libertarian.
I am fine with keeping the government from the slippery slope of punishing me when I say things it doesn't like to hear.
You are so... I'm not going to say it.
Thank you, Mr. Pesci.
All right, Judge Andrew Napolitano. Well, good news for the folks at the airports may be nearing. The new pat-down smackdown.
It is the first law of its kind. Citizens allowed to shoot police officers who trespass illegally.
Fox News senior judicial analyst Judge Andrew Napolitano is here to break down the new rule. All right, this is going to take place in Indiana.
It is.
What is it?
Well, it's a law that allows people who lawfully own weapons to use those weapons against the police when the police are behaving illegally. For example, police attempting to arrest someone without an arrest warrant, police entering property without a search warrant, police coming into the wrong property, or police actually committing a crime. Now, this was generated by a horrific case in Indiana where the police broke down the wrong door and arrested the wrong person, and he kept trying to say to me, I'm not the guy you want, it's next door. And the more he resisted, the more they pummeled him.
That sounds like the Texas law.
Texas also has a statute that if, for example, they're after Brian Kilmeade, but they arrest Steve Ducey, and he goes, I'm Ducey, I'm not Kilmeade.
Easy to confuse the two.
Easy to confuse the two. Ducey can, in Texas, Ducey can use force to resist
because I'm not the guy you came to get.
Correct.
I'm confused. So if the cops break down your house and you know that you've done nothing wrong, you can shoot them?
Yes. In the state of Indiana, yes. Well,
what if they have a warrant? If they have a warrant.
If they have a warrant, you cannot. So, look, the burden is on you to do the right thing. If you're not sure whether or not they have the warrant, obviously you can't use the weapon. You can't use the weapon to escape from lawful confinement. You can't use the weapon to initiate a crime. You can't initiate the confrontation
There's a lot of small print here.
with the police.
Yeah. Where'd this come from?
Well, this was enacted by the legislature and signed by Governor Mitch Daniels.
But why?
Because of this case in Indiana that received tremendous publicity where the police went to the wrong house and beat up the wrong person, and he attempted to resist, and then he sued the police, and he lost the lawsuit.
Isn't there a big leap from that to being able to shoot the police?
Well, as we were talking earlier, the state of Texas has had a statute where you can shoot the police, and people generally don't do it because the police are a little bit more careful because they know the homeowner may be legally armed as they are.
That's interesting. So where do you fall on this?
I'm in favor of the statute. I think it will lessen the tension between police and law-abiding citizens, and the example is Texas.
Let's just hope more cops don't get shot.
Correct. Nobody wants anybody to get shot, but nobody wants the police to break down the wrong door or to commit crime in the name of being a police officer.
Right, and that is now the law in Indiana.
Yes, it is.
Judge,
I don't think it's coming to New Jersey.
And we were talking about Texas as well. You were there yesterday. All right, Judge, thank you very much for joining us.
Pleasure, guys.
Now to our judicial analyst, senior Judge Andrew Napolitano.
Sure.
He's been through this for years.
Yeah.
He's always said the French hate him.
He has, and he is correct in that he has passed every one of the drug tests, blood tests that he's taken. There have been over 500 in his career. I read the letter against him, and it basically says, we've interviewed people who say they saw you doing this. We have a lot of corroborating evidence. We believe that you masked your blood. You masked the drugs in your blood so that when we tested you, it wouldn't show. All right, the Justice Department clears him. The allegations with the Justice Department were fraud because it was federal money. It was post office money. The same post office that's bankrupt sponsored him in France. So if he perpetrated a fraud on the post office, it'd be a federal crime. The Fed said, we don't have enough evidence to convict. But of course, the standard for conviction, proof beyond a reasonable doubt, is a higher standard than the standard the U.S. Anti-Doping Association has to show, which is clear and convincing evidence. An analogous example would be John Edwards, convicted of a crime, but he could still lose his license to practice law because the level of proof required to take his law license away is lower than the level of proof required to convict him of the crime. So that's what they're trying here. This is not a government agency, however, it is funded by the government. It's a private group that has a contract with all the people that run all these things. And when you participate in one of these events, you sign a contract saying, I will not take any drugs, and if I do and I win, you can take my victory away from me.
Of course, he hasn't been convicted of anything. In fact, he's passed all these tests. On the surface, at least, it looks like he's done everything right. Now there are allegations, and he can't compete?
Well, you also sign a contract saying that if you are accused of doing this, you won't compete until the allegation is resolved. So unfortunately, on the eve of this major event that he's about to participate in, he cannot participate in it. It looks as though this will not be resolved until around Election Day. It's nothing to do with the elections, but it'll take about 4 or 5 months for a hearing panel to be impaneled, for the case to be tried, almost as if it were tried in court. It'll be before 5 arbitrators, and then for them to give a decision.
I wonder if he was taking V.
What?
V.
What do you mean V?
Well, I mean, the sheriff took V.
Oh.
Do you not watch True Blood?
No.
Because V, you can get all amped up on V and do all kinds of weird things. You should watch True Blood. It just began on Sunday again.
Okay, thank you,
Because it'll make you crazy, the V.
It'll make me crazy.
You've seen the True
Do they
Blood,
respect the Constitution on V?
I don't.
Or on True Blood?
No, I think they have their own set of rules.
It sounds like it.